Dear students, after studying this module, you will be able to know about the introduction and constitution of Indian judiciary, structure of Indian judiciary, the competency and functioning of criminal courts in India. First, the introduction to Indian judiciary. The Indian judicial system is stratified into many levels. At the highest is the Supreme Court, which is followed by high courts at the state level, district courts at the district level, and lok adalats at the village and panchayat level. The judicial arrangement takes care of conservation of law and order by seeing cases associated to both civil and criminal violations. India has a quasi-federal structure with 29 states further subdivided into hundreds of administrative districts. The judicial structure, however, has an integrated arrangement. The Supreme Court, the High Courts and the lower courts establish a single judiciary. Generally, there is a three-tier division. Parliamentary democracy was envisaged in the Constitution of India works at union and state level. Especially in the making of law, there is direct participation of the legislature and the executive. It is the judiciary that safeguards the interest of citizens by not allowing the other organs to go beyond their role assigned in the Constitution. In brief, the Supreme Court of India is the logical and primary custodian of the Indian Constitution, while also being its interpreter and guardian. While the Parliament enjoys the authority to amend the Constitution, the Supreme Court has the authority to examine the congruency of constitutional amendments. The Supreme Court makes sure that other branches of government perform their responsibilities in accordance with the Constitution. Judiciary is the absolute authority in interpreting legal issues and constitutional arrangements. The nature of democracy and development of the state depends upon how the legal system conducts itself to sustain the overall socio-economic and political environment. Constitution of criminal courts in India. The judicial setup in India in the present day is an extension of the British legal system. The Supreme Court is the apex body, followed by 24 high courts, which in turn supervise and govern numerous district courts. Article 129 of the Constitution of India makes the Supreme Court a court of record and confers all the powers of such a court, including the power to punish for its contempt as well as of its subordinate courts. Article 141 of the Constitution of India provides that the law declared by Supreme Court is binding on all courts. Judiciary in India plays an important role of interpreting and applying the law and educating upon controversies between the citizens, the states, and many other parties. It is the function of the courts to maintain the rule of law in the country and to defend civil and political rights. As India has a written constitution, courts have an additional function of safeguarding the sovereignty of the Constitution by interpreting and applying its provisions and limiting the functioning of all authorities within the constitutional structure. In a federation, that is union of states, the judiciary has another significant assignment, specifically to decide controversies between the constituent states inter se as well as between the union and the states. While the power of the parliament to legislate is supreme, at the same time, the judiciary has been made the ombudsman of Indian democracy. The role of the judiciary has been ever-changing and has evolved based on the Constitution of India and the socio-economic needs of the country. The expression basic structure was introduced for the first time in the case Gokulnath versus State of Punjab. But it was only in 1973 that this expression was used by the Supreme Court, and it means and includes those features of the Constitution which lay at its principal need much more than the usual ways to change them. It was held in the famous Keshwananda Bharati case that any amendment which intends at abrogating the basic structure of the Constitution would be unconstitutional. Hence, every proposed amendment is subject to judicial scrutiny if it is intended at abrogating the basic structure of the Constitution. Constituent elements of the basic structure comprise the supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between the legislature, executive and the judiciary, and mainly the federal character of the Constitution. In addition, the judiciary also has the authority of judicial review. It indicates that every section of legislation passed by the Parliament is subject to judicial inspection by the Supreme Court of India. No detailed provisions exist for this arrangement. However, the power and extent of judicial review has been elucidated through various judicial pronouncements. The Supreme Court of India thus has the power to strike down any piece of legislation intended at amending the Indian Constitution on two grounds. Firstly, if the procedure prescribed under Article 368 is not followed, and secondly, if the amending act seeks to violate one or more basic features of the Constitution. In India, in addition to the above, the judiciary also has the significant function of protecting and enforcing the fundamental rights of the people guaranteed to them by the Constitution. The Supreme Court keeps a watch on the functions of the other branches of the state as to whether they are functioning in accordance with the Constitution and other laws made by the Parliament and the state legislatures. Now we shall see into the hierarchy of criminal courts. First, the subordinate courts. The subordinate judiciary in each district is headed by a district and sessions judge. The usual designations on the civil side are district judge, additional district judge, and the civil judge. On the criminal side, the widely known designations are sessions judge, additional sessions judge, chief judicial magistrate, etc. The governor, in consultation with the High Court of that particular state, appoints the district judges. According to the Article 233, a person who is not already in government service should have at least 7 years experience at the bar to become eligible for the position of a district judge. Appointment of persons other than district judges to the judicial service of a state shall be made by the governor in accordance with rules made thereunder. Besides the State Public Service Commission, the High Court has to be consulted in the matter of such appointments vide Article number 234. Sessions Court. As per Section 9 of Criminal Procedure Code, the court is established by the state government for every sessions division. The court is presided over by a judge appointed by the High Court of that particular state. The High Court may also appoint additional session judges and assistant session judges in this court. It has the power to impose any sentence, including capital punishment. Metropolitan Magistrate Courts. The courts of Metropolitan Magistrates were created by Section 16 of the Criminal Procedure Code. The Court of Chief Metropolitan Magistrate and those of the Additional Chief Metropolitan Magistrates were created by Section 17 of the Code. Section 18 of the Code also provided for the Special Metropolitan Magistrates. The towns having population exceeding 1 million could be declared as metropolitan areas. A metropolitan magistrate is under the general control of the sessions judge and is subordinate to the chief metropolitan magistrate. Judicial Magistrate Courts. Section 11 of Criminal Procedure Code states that in every district, not being a metropolitan area, there shall be established as many courts of judicial magistrates of the first class and of the second class, and at such places as the state government may, after consultation with the High Court by notification, specify. Courts of judicial magistrate of first class are at the second lowest level of the criminal court structure in India. According to section 15 of the Criminal Procedure Code, a judicial magistrate is under the general control of the session judge and is subordinate to the chief judicial magistrate. In terms of section 29 of the Criminal Procedure Code, a judicial magistrate of first class may pass a sentence of imprisonment for a term not exceeding 3 years or of fine not exceeding 5,000 rupees or of both. Next is High Courts. The High Courts are the principal civil courts of original jurisdiction in the state. According to the Article 214, there shall be High Court for each state, and every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself, vide Article number 215. The High Court stands at the head of the judiciary in a state. It enjoys civil as well as criminal, ordinary as well as extraordinary, and general as well as special jurisdiction. The institution of the High Court is fairly old, as it dates back to 1862, when under the Indian High Court Act 1861, High Courts were established at Calcutta, Bombay and Madras. In course of time, other High Courts have also been established. The High Courts of the respective state enjoys an original jurisdiction in respect of testamentary, matrimonial and guardianship matters. Original jurisdiction is conferred on the High Court under various statutes. The High Courts also enjoy extraordinary jurisdiction under Article 226 to issue various writs. Each High Court has supervisory power over subordinate courts under it. Each High Court, being a court of regard, enjoys the power to punish for its contempt as well as of its subordinate courts. Article 231 talks about the establishment of a common High Court for 2 or more states and a union territory by the Parliament. As in the case of the state of Haryana and Punjab, there is one High Court of Chandigarh. There is a High Court for each of the states except Mizoram, Arunachal Pradesh and Nagaland, which have the High Court of Assam at Guwahati as their common High Court. Goa is under Mumbai High Court. The government, as on 26 January 2013, has constituted 3 new High Courts in the northeast, Meghalaya, Manipur and Tripura, taking the total number of High Courts in the country from 21 to 24. The jurisdiction of the High Court of a state is coterminous with the territorial limits of that state. The original jurisdiction of High Court includes the enforcement of the fundamental rights, settlement of disputes relating to the election to the union and state legislatures, and jurisdiction over revenue matters. Its appellate jurisdiction extends to both civil and criminal matters. Next is Supreme Court. The Supreme Court has appellate jurisdiction over the High Courts and is the highest court of the land. The Supreme Court has concurrent jurisdiction with the High Court to issue directions, orders and writs for enforcement of fundamental rights as given under Article 32 of the Constitution of India. These are in the nature of the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. These writs make the Supreme Court a protector and guarantor of fundamental rights. The idea is that in case of violation of a law or right, the court may issue directions for obedience with the Constitution. The Supreme Court has the power to declare a law passed by the legislature null and void if it infringes upon the fundamental rights. The Supreme Court of India has 4 types of jurisdictions. First is original jurisdiction. Article 131 gives the Supreme Court exclusive and original jurisdiction in a dispute between the union and a state, or between one state and another, or between group of states and others. No other court in India has the power to entertain such disputes. Supreme Court is the guardian of fundamental rights and thus has non-exclusive original jurisdiction as the protector of fundamental rights. It has the power to issue writs such as habeas corpus, quo warranto, prohibition, certiorari and mandamus. In addition to issuing these writs, the Supreme Court is empowered to issue appropriate directions and orders to the executive. Article 32 of the Constitution gives citizens the right to move to the Supreme Court directly for the enforcement of any of the fundamental rights enumerated in Part 3 of the Constitution. Next is appellate jurisdiction. Under Article 132, Subclause 1 of the Constitution of India, an appeal shall lie to the Supreme Court from any judgment, decree or final order of a High Court, whether in civil, criminal or other proceedings. If the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this Constitution. Article 134 provides that an appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court. This appeal can be in 2 ways: without a certificate of High Court and with a certificate of the High Court. An appeal lies without the certificate if the High Court has on appeal reversed an order of appellate jurisdiction of the Supreme Court acquittal of an accused person and sentenced him to death, or has withdrawn for trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused person and sentenced him to death. Next is advisory jurisdiction. The Supreme Court of India also have advisory jurisdiction. Article 143 summarily reads as if at any time it appears to the President that a question of law or fact has arisen or is likely to arise, and the question is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it. He may refer the question for the advisory opinion of the court, and court may, after such hearing as it thinks fit, report to the President its opinion thereon. The advisory opinion of the Supreme Court is not binding on courts because it is not a law within meaning of Article 141. But in Re Special Court Bill, case 1979, the Supreme Court held that its advisory jurisdiction is binding on all courts in the territory of India. It also held that Supreme Court is under duty under Article 143 to give its advisory opinion if questions referred to it are not ambiguous and of a political nature. Next is review jurisdiction. The Supreme Court has the power to review any judgment pronounced or order made by it. Article 137 provides for review of judgment or orders by the Supreme Court wherein, subject to the provisions of any law made by the Parliament or any rules made under Article 145. The Supreme Court shall have the power to review any judgment pronounced or made by it. However, the Supreme Court jurisdiction may be enlarged with respect to any of the matters in the Union list as Parliament may by law confer. Parliament may by law also enlarge or can impose limitations on the powers and functions exercised by the Supreme Court. Next is International Criminal Court. The International Criminal Court (ICC) is a permanent international court established to investigate, prosecute and try individuals accused of committing the most serious crimes of concern to the international community as a whole, namely the crime of genocide, crimes against humanity, war crimes and the crime of violence. The seat of the court is in The Hague in the Netherlands. The Rome Statute provides that the court may sit elsewhere whenever the judges consider it desirable. The court has also set up offices in the areas where it is conducting investigations. Functioning of criminal courts. Administration of criminal justice is carried out through magistrate courts and sessions courts. The hierarchy of criminal courts is given below. The Indian Penal Code 1860, together with other penal laws, constitutes India's substantive criminal law. However, it cannot be self-operative. As a sequel to the Indian Penal Code, a Code of Criminal Procedure 1861 was enacted. The 1861 Code was repealed, after which a new Code of Criminal Procedure 1973 was enacted to carry out the process of the administration and enforcement of the substantive criminal law. In addition to the Criminal Procedure Code, the Indian Evidence Act of 1872 was enacted to guide the process of investigation and trial. The court at the lowest level is called Judicial Magistrate of the second class. This court is competent to try the case if the offence is punishable with imprisonment for a term not exceeding 1 year, or with fine not exceeding 5,000 rupees, or with both. The first class magistrate is competent to try offences punishable with imprisonment for a term not exceeding 3 years, or with fine up to 10,000 rupees. In states such as Kerala, the second and the first class magistrate courts have been integrated. The Chief Judicial Magistrate can impose any fine and impose punishment up to 7 years of imprisonment. The Assistant Session Judge is competent to impose punishments up to 10 years imprisonment and impose any fine. The Sessions Judge can impose any punishment authorized by law, but the sentence of death passed by him should be subject to the confirmation by the High Court. Now we shall conclude this module with a summary. The judicial structure has an integrated arrangement. The Supreme Court, the High Courts and the lower courts establish a single judiciary. Generally, there is a three-tier division. The judicial system in India is based upon the British legal system that was prevalent in the country during pre-independence era. The official language of the High Courts and the Supreme Court is English. The Supreme Court of India is the highest court of the land as established by Part 5, Chapter 4 of the Constitution of India. Articles 131 to 140 deal with the powers of the Supreme Court. There are 24 high courts in India. These courts have jurisdiction over a state, a union territory, or a group of states and union territories. They decide on both civil as well as criminal cases. The high courts are also termed as the courts of equity and can be approached in form of writs not only for violation of fundamental rights under the provisions of Article 32 of the Indian Constitution, but also for any other rights under Article 226 of the Constitution and under its power to supervise overall its subordinate courts falling within the physical jurisdiction of the same Article 227 of the Constitution. There are courts subordinate to high courts. These are set up by the state governments. The nomenclature of these subordinate courts differs from state to state, but there is a comprehensive uniformity in terms of the organizational structure. Below the Supreme Court and High Courts, there are subordinate courts such as civil courts, family courts, criminal courts and various other district courts which are involved in the administration of justice.